covering everything. Yeah, that happens.
Now, Judge, the district attorney of the Bronx, I understand you have to plead to the charge in the Bronx if you don't take his first offer?
That's only if you don't take the offer that he makes you in the criminal court. So that if you're going to, the district attorney in the Bronx has the posture, if you're going to play games with him and his staff, and they make you a legitimate offer on your case, and you're going to cost his office time and money, then their bottom line is they're going to try you on the original charge.
So tell me, what's happening in the Bronx now? Are they behind?
I think what Bob Johnson is doing in the Bronx is a good idea, and
well, I disagree.
I know he would disagree because as a management tool, okay, judges disagree because what Bob Johnson is doing is taking the authority away or the power from the judge and the defense or whatever to make a deal at a later date. I think it's good, and I think what the legislature needs to do and the state needs to do is to wake up to the fact that there is too much plea bargaining. But the only solution to plea bargaining is more judges, more courtrooms, and more jail cells. That's what's needed here.
So you like the Bronx approach. Why don't you like it, Judge?
First of all, there's no solution to plea bargaining. It's been there before. It's there now. It'll be there long after Dennis and I retire to our farms, wherever they may be. Okay, it'll always be there. Let's start off with that proposition. Secondly, what's happening in the Bronx is, in my view, unfortunate. Because what's happening is that the backlog up there is becoming enormous. When they started here, they were, as we say in the parlance, something like 50% above standard and goals. What that means is that the cases have been there too long. It is now up to 56%, and the administrative judge in the Bronx is pulling whatever he's got left of his hair to figure out how he's going to handle with
Judge,
this. And what Johnson is doing up there, and again, I don't mean to be critical, thank God we don't have this situation in Brooklyn. What Johnson is doing up there, he thinks he's going to force defendants to take what he's going to offer up front and not cause a backlog. But he's doing the exact opposite. He's causing a tremendous backlog. They're going to have speedy trial problems up there that he doesn't even imagine he's going to have.
Isn't there a rule that you must try a case within a certain period of time or otherwise the case can be dismissed?
That's what I just said, speedy trial problems. But if the prosecution answers ready, then the rest of that time is excluded. But it has to be a legitimate readiness declaration that judges can view with skepticism after they review the legal concepts involved. I don't think what's happening in the Bronx is good, very frankly, and I think they're going to have to change it.
And with that, maybe the District Attorney of the Bronx is listening. Thank you very much, Judge Aiello, Administrative Judge of Kings County and Richmond County. Thank you very much, Dennis Quirk, President of the New York State
Court Officers Association.
Okay, and as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program is made possible by the New York law firm of Zollman and Schnorman, who specialize in the field of personal injury law, located at 63 Wall Street in New York City.